by identifying the people in Garland versus Board of Professional Responsibility. This is the lawyer, Mr. Garland, and this is his non-lawyer staff, Miss Harris, whose responsibilities were communicating with clients and preparing documents. And this is Miss Snyder, whose responsibilities are answering the phone and filing. This is Mr. and Mrs. McKeog and Mrs. McKeog's daughter, and on the right is the biological father of Miss McKeog's daughter, Mr. Ashley. In September 2010, Mrs. McKeog hired Mr. Garland to help her husband legally adopt her daughter. Mr. Ashley came to Mr. Garland's office and signed an agreed order consenting to the adoption. Mr. Garland was not there, and his staff did not tell him that Mr. Ashley signed the order. The order was then mistakenly placed into the wrong file by Miss Snyder. In March 2012, Mr. Garland finally called Mrs. McKeog, and he then realized Miss Snyder's mistake. Since the case had taken so much time, Mr. Garland decided that an amended petition would have to be sent to Mr. Ashley to sign. In September 2012, Mr. Garland's office received the new petition, and Miss Snyder then mailed a copy to the McKeogs for their signature, but she mailed it to the wrong address. Mrs. McKeog sent several emails and left numerous messages and voicemails from September through November of 2012. Most of these were not even returned. Finally, on June of 2013, Mrs. McKeog filed a complaint with the Board of Professional Responsibility.
The infractions in this case have to do with RPC Rule 5.3, and Rule 5.3 states, with respect to a non-lawyer employed or retained by or associated with a lawyer, subsection A, a partner and a lawyer who individually or together with other lawyers possess comparable managerial authority in a law firm, shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. Subsection B states, a lawyer having direct supervisory authority over a non-lawyer should make reasonable efforts to ensure that the non-lawyer's conduct is compatible with the professional obligations of the lawyer.
Ways Mr. Garland was in violation of Rule 5.3, Section A was not in terms his fault, but his responsibility. For instance, during this case, Mr. Ashley was given petition papers to turn over his rights to his daughter. Mr. Ashley had avoided the signing of the documents for weeks, but had eventually went to Mr. Garland's office in person to sign them. Mr. Garland was not present for this transaction, but Ms. Harris was, and proceeded over it. Ms. Harris did not notify Mr. Garland that Mr. Ashley had signed over his rights to his child. If she had, then Mr. Garland could have taken the documents and gotten it signed by Mrs. Keogh to even further her case in getting her daughter. But because that Ms. Harris failed to notify Mr. Garland, Miss Keogh was never informed that the papers have been signed, and her case has just been stuck still because the documents were not given to the courts for it to be pushed to the next step. Another way the rule was violated was that with the papers being signed by Mr. Ashley, Ms. Snyder was to take the case and put it in Mrs. Keogh's opened custody file, but Ms. Snyder placed the documents in Mrs. Keogh's closed divorce file, essentially just throwing away the document because it's gone into closed case files where you don't touch them unless it needed to be warranted. meaning that Mr. Garland's not going to touch Mrs. Keogh's closed case file, so he'll never know that the documents were misplaced in the wrong files. One more way that the rule was violated was that Ms. Snyder mailed the amended petition signed by Mr. Ashley for a second time by the mishap of the document he signed it first was misplaced in the closed file. But Ms. Snyder placed this mailed the amended petition to Mrs. Keogh's previous home address, meaning Mrs. Keogh's address was invalid because she did not live there anymore. And the post office sent back the document to Mr. Garland's office. By this happening, Mrs. Keogh and her husband cannot sign the documents to further her case in getting her daughter, meaning that Mrs. Keogh is getting taken away time from getting to see her daughter and and just make memories with her because of a mishap of mailing. Easy ways to fix this rule from being broken doesn't necessarily involve Mr. Garland, but that of his staff. The non-lawyer staff should have been directed by the attorney to relay time-sensitive information, meaning Mr. Garland has placed policies and principles in his workplace for Mrs. Harris and Miss Snyder to follow. But if Miss Snyder and Miss Harris just went above that expectation line, they could have given back information to Mrs. Keogh and all other of Mr. Garland's clients in a very timely manner where the clients don't feel neglected or forgotten and that you don't get information about their very intimate situations that they're in right now. Another way to fix this is the non-lawyer staff should have paid attention to detail and ensured the documents are easily accessible, meaning Ms. Harris should have given Mr. Garland very detailed information of when the documents were signed, when Mr. Ashley appeared in his office, when she emailed Mrs. Keogh about information of her case, and Ms. Snyder should have seen that Ms. Keogh's address was invalid and that she had a new home address and that she accidentally placed the documents in her closed file, which made it inaccessible to Mr. Garland to further her case. If they paid more attention to detail, ensure that the documents were where they needed to go and where they were supposed to be, then Ms. Keogh's case could have been handled a lot sooner. One more way that the firm can fix this problem of breaking Rule 5.3 is that the non-lawyer staff should have communicated more effectively. Ms. Harris and Ms. Snyder should have talked between each other about information Ms. Keogh was giving about how Ms. Keogh's husband was leaving, so he assumed that if he left, he wouldn't be able to sign the documents, and the the moving from her previous address to her new address in Clarksville. By Ms. Harris and Ms. Snyder not talking, then both are missing out on information that could even potentially get Ms. Keogh even closer to getting her daughter where she needs her to be, which is with Ms. Keogh.
One issue that constitutes a violation of 5.3b is Mr. Garland did not ensure his staff was answering all inquiries from the clients. Due to the number of phone calls and emails left unread and calls not returned, the clients were forgotten, and Mr. Garland did not double check with his office staff that the firm was addressing each client's issues. A second violation of 5.3b was that Mr. Garland failed to look over the non-lawyer employee's work. Although he reviewed files once a month, it took him over 5 months to catch a mistake that was made. In order for Mr. Garland to ensure all his clients were receiving proper attention, he needed to review any important information that came through the office every week. Another violation of 5.3b is that Mr. Garland failed to supervise his staff appropriately and ensure his staff was engaging in professional conduct. Due to his number of clients being in the hundreds and usually being in court, he relied on his staff to take care of the office work in a professional manner. However, he did not supervise his staff properly, or he would have realized they were engaging in unprofessional conduct. In order to ensure he was running his practice under the Tennessee Board of Professional Responsibilities expectations, Mr. Garland could have had more policies in place for the non-lawyer staff. He should have had phone logs in place to ensure he is aware when inquiries are made on specific cases. He also should have had important emails filed in a way that he could view them to ensure the staff was answering all inquiries received. Mr. Garland could have also had a better filing system. He could have enforced a filing system that had all active files in one area of the office. He could have had recently closed files in another area to ensure any pending paperwork could be filed if it was received, and closed files over a specific time frame, say 90 days, should be kept away from the other files to ensure clients with multiple cases were not being filed incorrectly. By doing so, he would not have had to file an amended petition for termination of parental rights. Also, Mr. Garland could have taken time every week to ensure the non-lawyer staff have efficiently complied to professional procedures. He could have looked over previously specified phone logs and emails at the end of the week and take care of anything that may have been overlooked. He could have had his part-time employee, Miss Snyder, go through the files once a month and pull all the inactive files. He should have been more hands-on in the office and knew more about what was going on between his staff and his clients. Conclusion. Although the charges against Mr. Garland in this case originate from the lack of supervision of his non-lawyer staff, the board chose not to proceed against Mr. Garland under Rule 5.3 of the Tennessee Rules of Professional Conduct.